Other gap filler provisions provided by Article 2 include the default rules governing when the risk of damage or loss to goods passes from the seller to the buyer. This timing depends substantially on whether the contract has been breached and the type of contract involved. Section 2509 sets forth the rules to determine risk of loss, assuming neither party has breached the contract. Let's imagine a newspaper ordered 10,000 reams of newsprint from a paper mill. The paper mill agreed to ship the reams by carrier the next day. However, that night, the reams were destroyed in a fire. Who bore the risk of loss? To answer this question, we must identify the type of contract. Here, the contract authorized the seller to ship the goods by carrier, but didn't require the seller to deliver the goods to a particular destination. This is a shipment contract, wherein the risk of loss passes to the buyer when the goods are properly delivered to the carrier. To be properly delivered, the seller must put the goods in the carrier's possession, make a reasonable contract for the goods' transportation, obtain and furnish any documents necessary for the buyer to take possession of the goods, and promptly notify the buyer of the shipment. In our example, the reams were destroyed before the paper mill properly delivered them to a carrier. Thus, the paper mill bore the risk of loss. If the reams had been properly delivered to a carrier, the risk would have transferred to the newspaper. By contrast, let's say that the contract required the paper mill to deliver the reams to the newspaper's headquarters. In this scenario, the contract would be a destination contract, wherein the risk of loss passes to the buyer when conforming goods are made available to the buyer at the particular destination. Thus, here, the risk of loss wouldn't pass to the newspaper until the reams were made available to the newspaper at its headquarters.